Hello, my name is Tamara Rogers, owner and attorney of Rogers Law Firm. We service probate and estate planning clients throughout the state of Indiana. Welcome to Ask Tam. This is an informational session about a legal topic. Today's topic is, what is probate? If you are in a situation where you've heard the word probate, or maybe one of your family members has heard the word probate, there are a few things that have happened. One, someone that you know or close to you has died. And then the family members are usually trying to figure out how to pay creditors and what to do with the deceased person's things. Probate is a court-supervised process and a court process that explains in detail how a deceased person's creditors are to be paid and how to distribute the deceased person's things, which we call assets. There are a few questions to first ask in deciding if something has to go to probate. One, did the person who died have a will? If the person had a valid will but did not have a trust, then that estate may have to go to probate. And in the state of Indiana, that's called when someone dies testate with a T. Let's ask that same question. Did the person who died have a will? If that answer is no, then that means the person died intestate with an I. And even though the person did not have a will, the state of Indiana will decide what happens with the person's assets in certain situations. And so it's an example of, even though one may make no decision in terms of creating estate planning documents like a will, the state will make decisions for you in certain situations. The next question after you ask, did the person have a will or not, is decide, well, if the person had a will and without a trust, or if the person had no will, does the deceased person's assets need to go to probate? The answer to that is it depends. Some assets are included in probate and some are not. Some examples of assets that are not included in probate are those that have valid beneficiaries and what we call beneficiary designations. And so if the deceased person had a life insurance policy and valid beneficiaries, then the proceeds for that life insurance policy will go to that person pretty much immediately upon the person's death. Another example is if the deceased person owned a home in joint tenancy, or that means along with another person who's still alive, and if one of the people who owned the home died, then the rights to the home automatically go to the other person. That is not included into probate. So you then may ask, well, what does that leave that may needs to go into probate? Anything that is in the deceased person's name only will often have to go to probate if it's not one of those things that are left out of the probate, and if it is something that is titled. So let's go back to the home example. And so if there is a home that is only titled in a deceased person's name, upon that person's death, if the family member or a loved one is trying to sell or retitle that home, then that asset often has to go to probate to do so. And probate court will decide how the creditors are paid, who can be in charge of the estate, and the process that has to be followed. And so again, what is probate? Probate is a court process that the state of Indiana has established to explain how a deceased person's creditors are paid and how their things are distributed. You first ask, does the person have a will? If they have a will with no trust, or if there was no will, then probate may happen if the deceased person had something in his or her name only that was titled that the loved ones cannot get access to. Thank you for taking the time to watch this. Also, please like this video so that the algorithms out there can share it with others. And also subscribe if you're watching this through our YouTube channel. Again, I'm Tamara Rogers, owner-attorney of Rogers Law Firm, where we help you plan for all stages of your life. Thank you.